Title to the shares passes automatically by operation of law to the deceased personal representatives, typically the executors named in their will. Um, that happens immediately on death, but the company will not just update its register of members straight away. The personal representatives need to produce the grant of probate, and that can take some time. Until probate is granted, the company may note the personal representative's interest, but they generally cannot exercise voting rights or receive dividends. It's also worth the personal representatives checking the company's articles of association and any shareholders agreement early on, because those documents often contain restrictions, for example, preemption rights, and those will affect what can happen next. Yes, so this is one of the areas that can surprise people. The FCA's definition of a controller is quite broad, and crucially, it's not tied to being on the company's register of members. Instead, the test looks at who holds shares or voting rights and who can actually exercise significant influence. So, personal representatives could fall within that definition even before they are formally registered as shareholders, which is not necessarily intuitive. Normally, anyone who decides to become a controller needs prior FCA approval, and going ahead without it can be a criminal offence. But in this situation, because personal representatives acquire control by operation of law rather than by choice, the route is a bit different, and they need to submit a post-acquisition notification to the FCA. The key here really is to engage with the FCA early and to be transparent about the circumstances and explain interim governance arrangements while the estate is being administered. So this depends on the circumstances. Where the will is straightforward and the beneficiaries are clearly identified, a direct transfer may be the simplest. However, in more complex estates, it may be that the personal representatives register temporarily. That would allow them to, for example, vote the shares, receive dividends, and deal with company business while the estate administration plays out. And that can be important in circumstances where, for example, the executors need to fund an inheritance tax liability. But either way, the company's constitutional documents should be carefully checked. An onward transfer to beneficiaries could trigger preemption rights, consent requirements, or conditions such as the beneficiary needing to sign up to a shareholders agreement before registration. From a regulatory perspective, the transfer to a beneficiary is often a point that requires FCA approval, so the regulatory timetable should be built into the process from the start. The shares someone inherits might be in an unregulated parent or holding company, with FCA authorization sitting with a subsidiary further down the group. However, a change at the parent level can trigger an indirect change in control of that regulated subsidiary, even though the inherited shares are not in the regulated entity itself. Additionally, if a beneficiary already holds some shares in their own name and then inherits more, they might move into a higher controller band, and that brings its own notification and approval requirements. Finally, if you have multiple shareholders, including the beneficiary receiving shares here, and they are treated as acting in concert, their shareholdings are aggregated for the controller analysis. So FCA approval may also be needed for the group as a whole. The consequences can be quite serious. So if someone has decided to acquire or increase control and then goes ahead without FCA approval, there is potential criminal liability. And even where no offence has been committed, the FCA has a range of tools it can use. So, for example, it can impose conditions on a share transfer, or could actually direct that shares be disposed of to a third party. Beyond formal enforcement, there are some practical consequences to consider too: a damaged relationship with the regulator, reputational harm for the business and its owners, and potentially unnecessary friction at board level. However, the good news is that these issues are entirely manageable with the right advice and with early engagement. Being upfront with the FCA and sequencing the estate administration, company law, and regulatory steps really makes a difference.